Okay, I see Mr. Strine. And I saw Ms. Troutman briefly, but I don't see her now.
Judge, I think we're going to need to ask Ms. Troutman to return on her camera. I don't have that capability.
Okay, Ms. Troutman, hopefully you were able to hear that. We need you to, I guess, to try to turn on your camera again so that we can bring you into the oral argument. Oh, well. There you go.
Oh, can you hear me?
Yes, ma'am.
All of a sudden having problems with my technology over here. I apologize.
Not at all. No, we can hear and see you fine. So we're here for U.S. Bank Trust versus Alexandrina Dick. Ms. Troutman, you are here for the appellant.
Yes.
Do you wish to reserve any time?
Yes, please, 5 minutes.
Yes, ma'am, you got it. Go ahead.
May it please the court, my name is Shannon Troutman from Albertelli Law. As Judge Lucas stated, I'm here on behalf of the appellant, U.S. Bank Trust. This appeal stems from a foreclosure action where, following a non-jury trial, the court granted the borrower's motion for involuntary dismissal, stating that there was a lack of standing to the plaintiff. The order didn't elaborate on that at all, and the order stated that it was based on the testimony at trial, closing arguments, and case law cited. However, when you look at the testimony, it's clear that the only time that standing was contested by the borrower was standing at judgment. And the record reflects an overwhelming amount of evidence showing that U.S. Bank proved its standing at judgment, and there was no evidence or testimony elicited to counter that. So we are asking that the entrance of involuntary dismissal be reversed and final judgment entered in U.S. Bank's favor. As the record shows, U.S. Bank was a substituted plaintiff, and at trial, they entered a number of documents into evidence without objection, including the original note, which was endorsed in blank, 2 assignments of mortgage that showed a clear chain of title from the original lender, PNC, who was the original lender by merger. And those assignments also assigned the note. And the merger documents showing how the original lender, National City, was merged into PNC were also admitted into evidence without objection. So it's unclear what evidence or testimony the court was relying upon when it entered its order, because all of the borrower's arguments were based on the securitization and servicing agreement of the trust that the loan was part of. But that securitization and servicing agreement didn't have a master loan schedule attached to it. So there's nothing to show that it was even related to this loan. And additionally, the part that was entered into evidence of the servicing agreement stated that U.S. Bank Trust was the proper plaintiff in the action. There also entered the payment history, the notice of sale of ownership of the loan to U.S. Bank, all without objection. When you look at the closing arguments that were submitted by the borrower, they contain a number of references to documents that were specifically excluded from even being offered to the court, such as the HUD sale document. They reference their amended affirmative defenses, which they never set their motion for hearing. So the amended affirmative defenses were never, their motion to amend their affirmative defenses was never granted. So they're not part of the record. And they also state a number of falsehoods about what occurred at the trial, such as not being able to, being cut off and not be able to finish their case in chief, when in fact, on multiple occasions, the judge asked the borrower's attorney if she was resting, and she indicated that she was. There's overwhelming evidence that U.S. Bank proved standing at judgment, and again, we request that the entry of involuntary dismissal be reversed. And if your honors have any questions for me.
All right. Mr. Strine, we'll turn it over to you.
Thank you. Thank you. Good morning. May it please the court, Gabriel Strine on behalf of the appellee, Miss Alexandrina Dick. And we would respectfully disagree with Ms. Troutman's assessment of the case. And we would maintain that the order of the lower court was proper and therefore should be affirmed. Here, the appellant failed to meet its burden of proof by producing the collection notes. We don't even need to get into the substantive portions of this case per se, because there are procedural issues that arose in the middle of the trial and subsequent to the partial trial that indicate that the judge, well, not only indicate, but actually show that the judge, pursuant to Florida Rule of Civil Procedure 1.420B, had the authority to issue the order of involuntary dismissal. Here, the appellant, for over a year, and despite the lower court's 5 orders to produce the collection notes, failed to produce to the lower tribunal those collection notes. And as a result, this procedural failure gave rise to substantive problems. Those collection notes indicated that a third party owned the noted issue, and to that extent, they were immaterial to the defendant's case. And by withholding that, and by failing to provide properly redacted documents to the court, they prejudiced the case. They drug it out for over a year.
Mr. Strine, I want to understand, before you get too far into this, I want to understand, are you suggesting that as a, I guess, a tipsy coachman argument, we should construe the involuntary dismissal as if it were a discovery sanction when the trial court didn't make that express finding?
Your Honor, that's a fantastic question. I would maintain that here there are both procedural and substantive defects within the plaintiff's case. And to that extent, we wouldn't need to necessarily delve into that analysis. Specifically, there are substantive issues regarding the assignment of mortgage and whether.
Well, let me pause you there, because you brought up 1.420 and the procedure, and that does raise it did raise another question in my mind, which is, was there a reason why involuntary dismissal was urged upon the trial court as the way to resolve this case when it had heard from everybody? The evidence was all there. Whatever, I know that there really wasn't a huge amount more that was put on in the defense case, but it was the end of the case. Why not just ask the court to enter a final judgment in favor of the defendant on the standing basis, which would put this in a very different posture for purposes of appeal? I'm trying to figure out, why was this resolved in an involuntary dismissal when all the evidence was in and the exact same finding could have been put forth in a final judgment, which would have had more deference than an involuntary dismissal? That's
a fantastic question, Your Honor. I would maintain that here there was not all the evidence was actually in. Specifically, the collection notes are specifically noted in the trial transcript as not yet being in, and the judge requested that they be provided to the appellee and to the court within 10 days of the trial at that point. To that extent, not all the evidence was in, and therefore it was proper that the involuntary dismissal be issued, because there was the burden of proof had not been met. It's the plaintiff's burden of proof to show that it has standing. That's an elementary hurdle that has to be crossed before the appellant can actually proceed with any sort of foreclosure action and be entitled to a judgment.
Well, let's look at the evidence that was in, because we had, there's no question that PNC had standing at inception, correct?
Your Honor, we're not contesting that.
Okay, so then what we have is we have an assignment of the note and mortgage from PNC to HUD, and then from HUD to US Bank. And so if we look at the evidence that was in, why is that not sufficient?
Your Honor, if you look at page, I believe it's 884 in the record, is the assignment of mortgage. And if you look closely on the right-hand side of that assignment of mortgage, kind of about halfway down, you will see that it is executed not by a third party on behalf. And so to that extent, what we're looking at is there would have to be a power of attorney conferring the authority for that execution to take place. And in the absence of a power of attorney or some other document that confers that authority, that conveyance, according to this court's ruling in Koch v. Koch, is void. Koch v. Koch was very clear. That was a case where there was an issue regarding a power of attorney, and the agent overstepped his bounds of actual authority, and the court and made a conveyance that was improper. And the court stepped in and said it may have been done for good intentions, but nevertheless, to the extent that there's no authority, that conveyance is void. And similarly here, we have that exact same problem. We have an assignment of mortgage that's executed on behalf of, rather than by the party that would necessarily have to execute that document. And to the extent that there is no authority in the record, there's no power of attorney, no other document, no affidavit, demonstrating this authority to make this conveyance, it severs the chain of title, thereby creating a title problem that denies the appellant that standing at judgment.
Thank you.
So if I may circle back around to Judge Lucas's question, then you're inquiring as to the procedural portion of this, in regards to Tipsy Coachman, that substantive portion therein also would go to why we believe that this order of involuntary dismissal was proper. Furthermore, if I may also reflect on the record, the witness testified to a different chain of title than was presented by the attorney for the appellant. Specifically, the witness on page 759 of the record, lines 12 through 17, testified that the chain of title went from PNC directly to LSF9, leaving out the HUD transfer. And to this extent, this was a material differentiation from the record that was purported by the appellant. In the judge's order, it was very clear that he had made his finding based upon the test, among other things, the testimony of the witness. And here the witness's testimony was in conflict with the documentation that was purported by the appellant. And to that extent, we maintain that that is another substantive problem that runs afoul of providing the appellant with any sort of standing at the time of judgment. So here, if I may, my brief relied on several cases, but one of them is the case of Murray versus HSBC Bank. The citation is 157 Southern 3rd 355. And in that case, there was an issue of whether the bank possessed standing. And the court relied on a Maryland case of Anderson versus Barson. And there was a fantastic quote in there, and it says that if there are multiple transfers, the transferee must prove each prior transfer. And here, circling back to what we were discussing earlier with the assignment of mortgage, they didn't present enough evidence to prove that transfer in that particular case. They didn't fail. They failed to prove that there was a conveyance at that point, and more importantly, that conveyance was valid. Furthermore, as noted by my esteemed colleague, Ms. Troutman, there was a issue with the servicing agreement, which seemed to indicate that a third party called Volt actually owned the note. So what in that servicing agreement, a good portion of it's actually redacted. We don't know what all is actually contained in that document. It's provided to the appellee by the appellant, and was used by the appellee in its defense. The appellee pled that standing was an affirmative defense, and to that extent, it was the burden of the appellant to demonstrate that it did indeed possess standing. So, with that in mind, to the extent that the court has any questions, I'm happy to answer any of those at this time.
All right, thank you very much. Ms.
Thank you.
Troutman, your rebuttal.
Thank you. I'll start with counsel's argument regarding the collection comments. I'd like to note, as the court did, that the final order of involuntary dismissal does not mention anything about the collection comments. Additionally, the appellee filed numerous motions for sanctions. None of those were granted. So to say that that was the reason that the involuntary dismissal was granted is just not evidenced by the record. Additionally, during the trial, any questions that the appellee had regarding communications between the client and the attorney were specifically excluded, and all of the questions that related to something in the collection comments referencing questions about the proper party were all part of attorney-client privileged information. Additionally, the evidence that was admitted at the trial, again without objection, clearly shows that U.S. Bank had standing, and so the collection comments are irrelevant. Additionally, with regard to the second assignment of mortgage being executed by a third party and a power of attorney being needed, this was never raised at trial or before by the appellee. Again, everything was admitted without objection, and there were no questions on direct or cross-examination regarding the assignments. So I think that argument was waived. With regard to the statement that the witness testified to a different chain of title, if you continue to read the transcript, you'll see that the witness stated that Caliber had assumed the servicing rights from PNC. She was not talking about the note. So again, that's irrelevant to the issue of whether U.S. Bank had standing. And finally, the reliance on the securitization agreement stating a different owner, that seems to be the main thing that appellee relies on. Again, there's nothing to show that that servicing agreement is attached to this loan in any way. And owner is different than entitled to enforce. And the evidence shows that U.S. Bank was entitled to enforce the note and mortgage. So it doesn't matter who appellee keeps alleging that the owner was. So again, I would reiterate that all of the evidence on the record that was admitted without objection, and nothing was admitted or testified to that would in any way show any doubt as to the standing of US Bank, and therefore the involuntary dismissal should be reversed.
All right, thank you both. We will take a short 10-minute recess at this time, and then we'll reconvene with the next case, which will be Heckert versus Heckert.
Thank you.